Good evening, everyone.
Good evening, everyone. Welcome to Legal Hour with Connaughts once again. As you know, we have our usual expert on human rights, Sharia Khan, with us today, and we will be taking your live questions. So feel free to start sending your questions if you have any on any of the human rights issues, including the family and private life and 7 years child policy, which is a specific topic we will be discussing today in light of the new Home Office guidance and a couple of recent case laws that have come in recently. So, starting with the guidance area, as you know, Home Office has made some, I would say, significant changes, especially when it comes to 7 years child policy. How would you conclude that guidance?
Well, I think something I wanted to share was the recent case of AG, this upper tribunal's decision, and it's a very good decision in the sense that that case says that powerful reasons are needed before a child can be removed from the country. So, what used to happen before is that the Home Office, people would make an application with the 7-year rule, but it would go on to be refused by the Home Office, saying that although we accept that you've completed 7 years in the country, we still feel that you should go back with your family as a family unit. So they were playing that very smartly, and what they were saying is that your best interest actually lie with staying with your family members. So if parents are going back, who are possibly in most cases overstays, then the child also needs to go back with them. Right. Now, two things have happened as a consequence of the case of AG. Number one, what the upper tribunal has held is that powerful reasons are needed in order to remove that child who has now spent 7 years in the country. So what that means is that the burden of proof, if we may call it, was initially on applicants to show that if you've spent 7 years, you still need to show that there are reasons as to why you should be allowed to stay. Now that's changed. We moved on and departed from there, and the Home Office now need to give their powerful reasons as to why they should still remove that family or that child. And the second good thing that comes from that case is that it also says that if the parents have been overstayers, or if the parents have adverse immigration history, and I might actually say that this takes us one step further. What I've seen is we've obviously got this huge stigma of TOEIC cases, 40,000 cases affected, and a lot of those applicants are now making applications where their children have completed 7 years. And the Home Office played the TOEIC card again to say if one of your parents have done an ATS test, your people of bad character, or your parent is a person of bad character, and you have to go back. And the judge again, the upper tribunals held that it might not be sufficient. A parent's immigration history is not sufficient, which I guess means even if a parent has done an ATS test, although that's another debate as to whether it's genuine or not, it would not count as a reason on its own to say we're going to refuse the entire family from staying in the country. So yeah, that's the case of ET, which is very helpful, and I think you want to touch upon the guidance as well.
Yes, I mean, how would you compare this case with the previous decision of Court of Appeal, which is, I think, MA Pakistan, which also touch on the same point, where it's, I wouldn't say a slightly stricter decision, but that decision had more room for Home Office to use it against the applicants.
Exactly. That's what the Home Office was doing. That they were using that case against applicants in the sense that in the Court of Appeal, in the case of MA Pakistan, said that a parent's immigration history will play a role in the consideration of applications under 276 AD. And the Home Office took that to mean that if a parent has a negative immigration history, then we'll use that against you. And not necessarily perhaps what the Court of Appeal meant, but that's definitely now been clarified in light of ET. So I'd say that that's, although if there was any confusion arising out of the Court of Appeal's case in MA Pakistan, that's now been clarified, and that's clarified in favor of applicants. And yeah, it's excellent news. So definitely people who will make such an application under the 7-year rule know now that the case law appears to be on their side, and they should have successful outcomes in the cases.
Sure. And in terms of the guidance, because new guidance, as compared with the previous one, touches on a lot of issues in terms of parents' immigration history, and in the guidance, the specific scenario given that if parents have continuously overstayed in the UK, then it will be used against the applicant, and unless applicant has some circumstance where, for example, applicant has some medical condition, child has a medical condition that cannot be managed outside of the UK or is being managed very well within the UK, etc. So, how would you compare that guidance with these case laws?
Well, I mean, I guess what I've always said is, and I'll say again, I've got a lot of problems with that guidance. I wouldn't agree with that guidance for a number of reasons. One is the example that you gave. Now, that is going from a human rights case into a borderline humanitarian protection case, when the Home Office gives an example that we will not approve such applications if the child is getting treated here and has got a medical condition. Now, that's an Article 3 case, and the Home Office needs to understand that this is obviously, these 276AD applications are entrenched under Article 8, under human rights, and the consideration has to be that if the child has completed 7 years, then the burden has to shift, and the supposition has to exist that the child is now settled in the country. The best interest of a child under Section 55 is that that child should be allowed to stay in the country. But that's not what the Home Office's guidance says. It appears to ignore Article 8 in its reality. It appears to ignore a lot of leading cases on this point. And I think now, in light of ET, they might want to revisit this guidance again, or otherwise it's just going to be a case where the guidance will be there, but hopefully the judges won't really be giving it due weight. So that's my view on that. So I don't think I would be dissuaded or discouraged by applicants or by lawyers who read the guidance to say, this is going to get tougher, because the rule is there. 27680 is very clear. If you've completed 7 years in the country, and now in light of ET, the Home Office needs to give powerful reasons as to why the family should go back. And if the parents have, as you said again, breached immigration control in the past, it's a very basic principle, I suppose, in law, that the sins of the parents cannot pass on to the children, and that should not be happening. But I guess that's again something that the courts will have to expressly tell the Home Office before they change the guidance.
Well, I guess looking at these two cases, courts have, in one way or the other, have told Home Office expressly to change this guidance slightly. So, moving forward, you think 7 years route applications where child has recently turned 7, let's say child is born in the UK and recently turned 7, these applications will have more strength now based on these case laws, or you think the Home Office will continue with the same approach? How do you think moving forward the Home Office will look at these?
It depends, you see. I mean, after we won the case of, as in the ETA Stoic case, we thought we'd see a huge change in the decision-making process of the Home Office. But it appears that they never really want to follow the decision when the courts take a decision. They don't want to follow it to the letter. They want to find still a solution or a case that supports them. So just stepping away from your point for a minute, what should have happened following on from the case of Essen is that they should have just thought about the fact that the Court of Appeals considered everything, Silks are presenting the case on both sides, all the arguments have taken place. There was never really a point to appeal that case to the Supreme Court, but they decided to do that, making grounds, well, I won't get into the grounds. And now they're looking to, now it's being settled and withdrawn. But again, if you look at the policies that are being put in place, they should have just said that yes, we got it wrong, special decision under Section 10, we should have given a right of appeal, here you go, we're going to do that. But they are unnecessarily burdening the entire judicial system by now telling everyone that we're going to grant you permission, but these cases are now going to get listed again at the upper tribunal. So they want to now again have another bite at the cherry, or perhaps want to seek to re-argue the case in a different way. So coming back to your question, I would hope that they would just look at everything and decide that if a child has completed 7 years, and if there's nothing terribly serious, I'm not saying if the parents are criminals, they should still perhaps, the 7-year card should be a trump card. But yes, if it's just adverse immigration history, then that should not be sufficient, and the Home Office should start approving these applications once a child completes 7 years in the country. And let's hope they do that, otherwise it's just another case of us, the lawyers, burdening the appeal system, because we don't have a choice, we have to go to the courts. Because what they also do is, they refuse your case, which is fine, but then they also certify it as without merit. So then you first have to go to the upper tribunal, lodge a judicial review at the expense of the state if they have to pay the cost, or at the client's cost if if the case gets settled early and you don't see costs. And then you go around and then appeal it. So what's the point? At least the certification should not be there. If the Home Office disagrees, refuse the case, give them a right of appeal.
Right, excellent. Well, we've got a lot of questions coming in. First question I have is actually not relevant to the topic, but it's a very simple question, so we'll answer it anyway. Someone has asked if they require the university's permission to apply for a Tier 2 general visa if they are on Tier 2 student visa. Answer is no, you don't need your university's permission as long as
Yes.
you've finished the course and you have a degree. In fact, as long as you've finished the course, you don't even have to wait for the degree anymore. I think under the new guidance, you can still make an application.
I hope that was clear. So just to clear, you don't need the university's permission. Once you've completed the course, you can go ahead and get sponsorship from your Tier 2 sponsor and make an application to switch. And as I said, you don't need the actual degree, or you don't need to wait for your graduation ceremony. As long as you have a confirmation letter from the university which confirms that you've been awarded the degree, you can go ahead and make the application for a Tier 2 general visa.
Right, excellent. I've got some questions with regards to, I think we've covered enough on new guidance and 7 years policy. We've discussed the relevant recent case laws as well. Just to summarize, if you have a child who's turning 7 or has turned 7, it's a very good time to make those applications because based on this recent case law, I think we have very strong grounds to proceed with these type of matters and argue positively, a very positive case that a visa should be granted to the child. And parents' immigration history should have very less input into a decision-making process when assessing the application itself. We have some questions with regards to EEA regulations. This is a very interesting question. This is the type of question we were discussing a couple of days before as well. If someone is an extended family member of an EEA national, spouse, let's say they have a residence card, but later on they register their marriage in the UK. Now they have finished 5 years from the date of their relationship and not from the date of residence card or the registration of marriage itself. Question is, can they apply for permanent residency?
Well, the simple answer in terms of calculating your 5 years residence as an EA family member is if you are under the marriage route, then it's not the date of your biometric resident card, it's not the date of your visa, it's actually the date of the marriage itself. Because from the time you got married, you became an EA family member, and therefore you just need to clock up 5 years and then you can make an application. It gets complicated when you're a family member but on the basis of being unmarried partners. That is the question, right? So if you've lived together with your partner for 2 years and then you make an application, then that relationship is only recognized by the Home Office when they approve your application. So therefore the starting point for the 5 years is not from the point you started living together, because bear in mind your relationship only became equal to marriage or a durable relationship once you completed 2 years together. So that point actually is still going to be relevant for the calculation of 5 years. So you would need to calculate your 5 years from the point you were granted the visa, the 5-year visa. Once you complete 5 years, which would be close to the period when the visa, the leave is expiring anyway, or let's say the recognition of the EA treaty right is expiring anyway, that's when you make the application for permanent residence.
Well, just a follow-up question from that. If a lot of people ask if they have been granted a residence card as an extended family member on cohabitation basis, can they apply for retained right after 3 years if they haven't registered their marriage?
There isn't anything in the rules for such a scenario. So that's something that's always again bothered me, and a good judicial review might perhaps change that, or maybe a reference to the European courts on this point, but there isn't anything for unmarried partners. So I suppose that has some implication on same-sex partners. to say that they are being prejudiced by this law because it only caters to applications under the marriage route.
That's right. So even if you're a same-sex partner, still, if you haven't registered your marriage and your relationship from the date of residence card even lasts more than 3 years, once it ends, it ends. You have no further recourse.
There's no retain right. Yeah, there's no retain right. So marriage is definitely a stronger recognition, I suppose, in terms of these rules.
Sure. Coming back to our original topic, I've got a question from Vinesh. States, what if 7 years are not completed but a child spent his cognitive 4 years in the UK and life in the country of origin will be very difficult if sent back? Can a child still be able to get a status?
Well, yes. I mean, just going back to when the rules were, when the 7-year rule was at one point removed in Parliament, and they were considering, because back in the day it used to be a policy, a secret policy, not really a policy that was on the books, and it came on the books and it got removed, and then we had 276 ADE. What the Home Office's position or the Secretary of State's position always has been is that 7 is not really a magic number. And now, so to answer your question then, even if you've completed 4 years, but those 4 years are the cognitive years, as you said, or the formative years, as the Home Office considers, and let's say if a child comes to the country when he or she is 4 or 5, so as soon as she comes into the country, she starts going to school. So then we've got a case where somebody's gone to school for 4 or 5 years. So a child who's born in the country, who's completed 7 years, would roughly have 3 or 4 years of schooling, and that's what happened in your scenario. So that application should have the same force, and that's actually interestingly been considered again by the upper tribunal in a recent case, where they say that we need to see, and the Home Office actually in the recent guidance also mentions this, that where does this child's social ties lie? So in the first 2 or 3 years, the social ties lie within the family, but once a child starts school and starts building relationships outside her family, then she's got a case under 276 AD. So not under 276 AD necessarily, because you would have 7 years, but you would still be successful under human rights.
Excellent. So the short answer is you can make an application.
Can make an application, not strictly under the immigration rule for this, but under human rights.
Yeah. And we have had recent cases where children haven't lived here for 7 years, but they have developed very strong private life of their own. For example, if they have been going to school for the past few years, and obviously they are friends, etc. We have done those type of cases as well.
I think both of us have had successful cases where children they came later, but they were doing very well at school, and they've just been in the UK for less than 7 years, 4 or 5 years. We've had success in those cases.
Well, just to add on that, I mean, even cases where a child is now over 18, slightly over, less than 19, 20, haven't spent half their life in the UK, so it does not fall within 276 ADE, between 18 to 25 years category, yet spend a lot of time going to university or high school in the UK, have very strong private life. These type of cases, again, we have dealt with, and I think we would advise the same, that applications can be made, not within the rules, but outside of the rules, and obviously given a fair chance. I think these are the type of cases we should look into making an application for. Okay, a lot of questions are coming in on 7 years policy.
Somebody is asking that if their wife and husband will also, and the parents also qualify at the same time. So yes, if the families made an application together and one of the children are over 7, then the entire family benefits from a grant. Of course, it's based on the fact that the child's completed 7 years, but yes, if everybody's made an application together, depending on the child, some solicitors like to make an application for the child first, and if that's successful, then they go ahead and make an application for the family members, for the parents. But if they made an application at the same time or later, as long as the child is successful and the Home Office accepts the qualifying criteria is met for that, then everybody would be entitled to leave to remain.
I mean, there's a same-day service available for these type of applications as well. Now, if child has been successful, then parents can even apply on the same day.
Exactly. You don't really need to make a postal application within the 3-4 months. If you don't want to, if it really matters, time really matters, and you can afford it, then you can do same day application.
Yeah. I was going through the new guidance again, and there is no mention of Zumbrano in that guidance. What is mentioned is that they have tried to bring policy where child is a base citizen. That policy in line with 276 AD where child is not a base citizen. So same rules are being applied now to a child who is a base citizen and has a parent who is a non-EU national.
Yes.
How would you?
I didn't. Yeah. So what was your criticism?
Well, basically, previously, if you have a child who is a British citizen, then this is a type of consideration that will carry a lot stronger weight as compared to a child who is not a British citizen.
Yes.
But now that was under European court case.
Yes.
Zambrano. Yes. Now they have got that policy in line with a child who is not a British citizen. So if you have a child who is a British citizen, but parents, father or mother has a bad immigration history, Home Office is saying in the new guidance that same weight should be attached to child's nationality as compared to a child who is not a British citizen, which is very surprising.
Which is very surprising because it's just completely against, as you said, a leading judgment, which led them to change it. But it developed a whole new area of immigration law altogether. There's a Zambrano principle in the cases to follow. So I would again think the courts are very, very unlikely to agree with the Home Office's position on this. If a child is a British national, then as following the case of Zambrano, you really need to show that that child will not be deprived of any fundamental rights that he would be entitled to as a British citizen. So if a child is being sent back to Nigeria, how do you demonstrate that he's going to get the same rights or the same life that he would get here? And I guess I was discussing this with a leading silk that I'm working with on the case next week. And the point that the courts are toying with these days in terms of the Zambrano principle is whether it is a question of choice or compulsion. So whether the child will go by his own choice. So they will say, we're not forcing the child to leave the country. The child is a British national, he can stay on. But just because the father is, again, just give an example, is a Nigerian national, and he's being removed, so there's a choice that either the family, or let's say the mother is also British, it's a choice that family makes, and they're not being compelled. So the Home Office's definition of compelled is that we're not arresting you and putting you in a plane, but you can't do that anyway. You cannot. Well, interestingly, I think it's in social media these days that there's a British national who's been detained for the last 4 months because they can't establish whether he's British, but that person alleges that he's been here for the last 47, 50 years of his life. So I mean, just going away from the topic for a minute, I think what the Home Office wants to say is that we will give, as you said in the new guidance, the same consideration to a child who's British and non-British, but that's definitely not going to work. So a father or a parent who's not a British national or not an EU national is not really going to have the same level of treatment that's going to be served upon these other human rights cases.
And putting it slightly differently, parents of those children who are citizens should get some better treatment as compared to those parents who don't have child who's a British citizen in the UK.
So do you mean in a scenario where one of the parents
outside of the Zambrano principle?
So do you mean a scenario where one of the parents is a British national as well?
No, where a child is a British citizen, parents are not, as compared to a child who is not British citizen but lived here for 7 years.
Well, I guess again this is the Zambrano point, isn't it?
Yes.
This is a very square Zambrano point in a reverse way, where it's not a British child, where it's the child is British, but the parents are being removed. So the child has no choice on this point. The child will be compelled to leave the country if the parents are being removed. I don't think that's going to work. So if the Home Office intends to do that, they will be struck down by the courts.
Sure. Okay. What about the people that are coming from the Caribbean? I think same principle applies to non.
Yeah, I mean, I'm not sure what you mean by that. What about them? But if your question is that there is a family from the Caribbean and they have a child who's 7 years or even less, but forming their cognitive formative years in the country, it's the same consideration really. Either, I mean, The point is that if you're not a European national, if you're not a British national, then whether we give an example for Nigeria or from the Caribbean, it's the same law, pretty much. Yeah.
Well, one question I wanted to ask. Now, after Sala was overturned, which is slightly different from our topic, it's again under EU regulations. Right of appeal for extended family members was taken away after the ruling of Sala, and that was overturned later by Court of Appeal. Now we're still getting the decisions from the Home Office. I'm sure you've got some as well, where right of appeal is still not given to extended family members.
Yes.
And these type of cases we're getting very regularly. Now, how would you advise these people? What can they do with these type of cases?
Well, they're in a better position now following the Court of Appeal overturning, as you said, the decision in Sala. And it's another application for judicial review, but a stronger application for judicial review, because now the Court of Appeal is agreeing with the point that there should, in theory, be a right of appeal, or there should be an internal process of challenge, and that, of course, is an appeal.
Sure. I mean, they've also started differentiating between partners living together or other extended family members. So if you have, for example, a cousin you're sponsoring as an extended family member, definitely there's no right of appeal from Home Office perspective. But if you have a partner you're living with as an extended family member, some cases they are giving right of appeal, but there is no consistency in the policy.
Yeah. I mean, that's what I was going to ask you. That have you come across something in the policy that says that they will distinguish between? I haven't seen anything.
No, nothing in writing. No.
So it does appear as if the Home Office thought process appears to be that if it's a partner, then it might possibly be a case. So they'll refuse it and give you a right of appeal, and then you go to the courts and prove it. But if it's an application of the extended family member, it somehow seems to attract a stigma, and the Home Office just doesn't want to believe that an uncle is genuinely supporting a nephew in the country. They just want to refuse it, and they don't want to give a right of appeal as well following Sala.
Sure. I think it'll have to be our last question. In our last discussion, and after that discussion, we had a lot of questions on that particular point. If someone hasn't finished 7 years and wants to make an application still for any reason, maybe they have to go for reporting, etc. They just want to make an application, come back into the system. Can they make further representations after child has reached 7 years in the UK? So, for example, let's say they have 3 months remaining, they make an application. By the time a child reaches 7, there is still no decision on the application. So can they make further representation, partially valuing the application?
They should. I definitely think they should. Just in order to prevent themselves from the Home Office saying that you were not 7 at the date of application. So then, you've just covered yourselves. Obviously, it's not the best practice for us it's difficult as well if a client comes to us, as you said. To tell them, yes, wait for 1 year, don't make an application. I'm not comfortable with doing that. It's a client's decision at the end of the day, but it's good practice to get your immigration history in order and make an application. If you think your child is going to be, not if your child is going to be 7 in a few months, then there's always an option to make it by virtue of a section 120 if you've got a refusal in the past, or by virtue of making further submissions, inform the Home Office that the child is 7 years old, perhaps attach the birth certificate again just to remind them that that's the calculation. Maybe get another report done. If you're relying on an expert, maybe there's been 6 months since that report's been done. You could just have that report redone in light of the fact that the child's 7. Not that I think that expert would reach a different conclusion, but still it would solidify the point. So I would again go towards what you suggested, yes, and make an application, but inform the Home Office when the child turns 7.
Thank you very much, Sharia. I think we've covered all the topics we wanted to cover today.
Thank you, everyone. Sorry we couldn't answer most of the questions that are stemming through some of the discussions go deeper and longer. But we will email back most people who are messaging us and emailing us.
Sure. And if you have any further questions, you can email us at our inquiries email address. You can email Sharia, you can email me directly. Book an appointment, come in, and we can discuss your first consultation. Is always free. And thank you very much, all of you attending. If you have any further questions, we're happy to help. We will be here in 2 weeks' time again. So if you have any questions, write them down, save them somewhere, and we'll be happy to answer them when we come in next time. Thank you very much.
Thank you.